Assalamu alaikum rahmatullahi wa barakatuh. Welcome to Season 3 of Legal Ease, the show that converts legal jargon into legal ease. The last week's show was our first show back for the season, and you met with my co-host, Mr. Ashraf Esop, and he gave you some insightful and interesting information relating to the RAF, that's the Road Accident Fund. And he had an expert guest on the show which sort of really enlightened us on what happens on South African roads. And you've just come back from your December holidays, and I'm sure, please God, inshallah, you haven't had any accidents or anything of that nature. But if you did, hopefully that show was very helpful. Well, tonight, just like every other season and every other show we've had, we have only the highest quality legal experts for the show to educate you, the viewer, our most valuable asset, on what it is you need to know about the law. And I say that you are the most valuable asset because it is only with your support, your loyal support, and the fact that you sit at home every Thursday night and watch this show, and of course with the barakat of the Almighty, subhanahu wa ta'ala, it is that we can bring you and continue bringing you only the best and top, highest quality education. Tonight we have, is no different. Of course, we have another legal expert, a gentleman by the name of Louis Kruger, who is an expert in the property law sector. Now, Mr. Kruger is going to be assisting us with tonight's title of the show, which is Sectional Titles, Building Blocks to a Firm Foundation. So let's welcome Mr. Kruger and let him educate us a little bit as to where he's come from, and then also talk to us a little bit about sectional titles. And you'll hear just now that if you in fact live in a townhouse complex or in a cluster which has sectional titled homes, or you live in a block of flats perhaps and the flats themselves are sectional titled, and you're not quite sure what it means to be sectional titled, Mr. Kruger is going to assist us with that too, and he's going to explain to you whether or not you should get involved in this scary thing called a body corporate, and whether in fact you are already involved. And then goes a little bit further, Mr. Kruger will explain to us about trustees and the board of trustees and what it means to be on this board of trustees. Do you have rights? Yes, you do. The moral of the show, as you always know, is you do have rights. Know those rights, learn those rights, and if you don't know them or cannot learn them, then make sure you find someone, in this instance, like Mr. Kruger, who does know them so that they can assist you to fully exercise those rights. So let's turn now to Mr. Louis Kruger. Louis, thank you so very much and welcome to the show. Thank you for being on here and thank you for assisting us tonight.
Thanks, Nadeem. Thank you for the opportunity. Just a bit about myself. I'm from Schindlers Attorneys. We're a full-service law firm based in Melrose, Johannesburg. I personally am a member of the property law team, primarily a conveyancing practice, but we do deal with all aspects of property and municipal law. I'm personally involved in day-to-day conveyancing. I have a particular interest in developments, sectional title developments being obviously the greater, and also actively involved in education and training of estate agents who are completing their requirements for their professional designation examination, which is now required of all estate agents to practice in South Africa.
Okay. And you say estate agents, but if I'm to understand it correctly, it's also required of managing agents.
Correct. Managing agents are estate agents who have a particular interest in managing sectional title developments and clusters or homeowners associations. So the requirements for them is exactly the same as an ordinary real estate agent doing property sales and rentals.
Louis, now I know from being involved or being on the board, should I say, of certain commercial and residential trustees with developments, or should I say with complexes, I know that it's no easy task being a managing agent or being this source of advice to owners. I mean, you've got many different mentalities, many different personalities, cultures and background, and you expect them to all now get along for the greater good of 30 or 40 or 50 other residents.
Yes, no, definitely. I think the challenge faced by many managing agents, as you've mentioned, the personalities and the different owners and their needs that have to be managed, but also simply because sectional titles are governed by quite complex legislation, the Sectional Titles Act and the prescribed management rules. So there is at all given times quite a substantial amount of statutory knowledge required, and then obviously the day-to-day management of the scheme.
Yes. Louis, as you know, as I've mentioned to you and also mentioned to everybody else times before, this is an interactive show. The show is live, obviously, as you know, and we take your calls and we take your questions, and tonight is no different. In fact, we're going to be opening the phone lines from now in the next few minutes, so that you can call in and ask us these questions about these sectional titles. Mr. Kruger is going to inform us just now that a lot of these body corporates are now reaching their financial year end, or have reached their financial year end already. And in accordance with the rules, Mr. Kruger, they've got to have
their annual general meeting.
Their annual general meetings, right.
Yeah, within 4 months of the close of their financial year.
Perfect. So you guys most likely have 4 months to get yourselves ready for this AGM if you ended in January or ended the 28th of February. And if that is in fact the case, then you need to ask as many questions as you can, because we may not have another show closer to your AGM. So the number to dial, as you always know when the lines are open, is 011 086 7700 or 1 or 2 or 3. Again, the number is 011, which appears on your screen, 011 086 7700 1, 2 or 3. So please call us if you have any questions that you'd like to know about the sectional titles while we continue with our discussion. So Louis, you were mentioning all the different elements of property law that your firm is involved in. That's Schindlers Attorneys. And what I found interesting was that you went from conveyancing all the way to advising on body corporates. What's funny there is that it actually kind of goes full circle, if I'm not mistaken. You sell a property, do the transfer, and then the process continues thereafter. You've got give us an example. So it's a full spectrum process.
Yeah, our relationship with our purchasers and sellers obviously commences with the conveyancing process, right. And we find quite often that we will be called many weeks or even months or years after we've concluded a transaction for advice. People are ignorant often of their rights and responsibilities as owners of sections in a sectional title development. Mm-hmm. So we find that we are quite often giving advice not only to managing agents, but sometimes directly to the owners of the various sections.
Mm-hmm. What struck me with your introduction, Louis, was that you also deal with the municipal element of it, which is extremely important and equally extremely excruciating for certain residents to deal with. Yeah. I know that there are people who have many issues with regards to, especially new developments. Just give me an indication, what is the process with regards to a new development, the setting up of a sectional title scheme, and more important, or equally as important, the registration of an account, of the rates account with council? Whose responsibility? What's supposed to happen there?
Nadeem, you're very correct. It's a very frustrating process quite often for developers and owners of new sections. Once the sectional title scheme is open in the deeds office and the units have been transferred to the owners, the municipality has to open individual rates accounts for the various sections. There were changes in our legislation in recent years where the individual units are now ascribed a municipal value, and rates are payable to the council in respect of that section. So upon registration of a new scheme, we would submit as the conveyancers all the required documents to the municipality, and generally in our instance the City of Johannesburg, and they would then be tasked with getting their valuers to go and independently value each individual section in that scheme, calculate the rates, and then commence billing the new owners. Yes. From experience, that process can take anything from 6 to 12 months. And only if we're very fortunate is it done accurately and comprehendibly. Yeah,
that's actually one of the things I was going to ask you, and I actually thought it was a curveball for you, but you kind of already answered it. Is it when a developer is developing, so he applies for the sectional title to be opened, sectional title register to be open, right? And he now says that he's got subdivision, excuse me, and he wants to build 50 units on this, 100 acres piece of land, for argument's sake. He opens up a section title and he says, these are how many sections I want in the property, in the piece of land, on the development. Is it then his responsibility to go and open up that account with council?
What the general understanding is that the underlying property is generally registered in the name of the developer. Right. So at at the beginning of the development, we would obtain a rates clearance certificate from council relating to the underlying land, which obviously affords protection to the body corporate post-registration. But once the scheme is established, the onus will fall on the body corporate and the individual owners to open those individual accounts.
When is that? When is the scheme established for purposes of the Act?
There's often quite a bit of confusion. The scheme, the register in the deeds office can be opened prior to any individual units being transferred to any third party. So the developer could approach the deeds office, open the sectional title register in his own name, and decide to only transfer the individual units at a later stage.
Right.
The Sectional Titles Act clearly states that upon transfer of the first section in the scheme, regardless of the number of sections transferred, even if an individual section is transferred, immediately upon registration of that first section, the body corporate is deemed to be established.
Okay, so that's very important, and that's very important for all of you sitting at home, that if you've just moved into a property or you've just bought a property in a turnkey type development, this is important. You need to know that your scheme is established and that you now have some responsibility in respect of the rates account. The reason why I say that is because of the following, Louis. So now the developer has opened up the account. Right? He has been utilizing water and electricity on this property for purposes of his development.
Yeah.
He's been receiving draws from the bank from each owner who is now building on this property. He's been receiving draws to develop this property, to develop the units. He had to allocate or budget a certain amount of those draws for purposes of water and electrical usage. But what this smart aleck hasn't been doing is he hasn't been paying his rates, he hasn't been paying his water, he hasn't been paying electricity, and now the properties are 70% built. So now they've been transferred, the scheme is essentially established, and now here comes City Power and City Joburg and knocks on the door and says, hello guys, you now owe us 200,000 Rand or we're disconnecting the power. Who do we turn to?
Yeah. That's a very, very real dilemma that owners, and especially in new developments, are facing. And that is why I think the Sectional Titles Act makes it abundantly clear that an inaugural general meeting, so the first general meeting of the body corporate, must be held within 60 days from the opening of the register and the transferring of the first sections.
Okay.
And that in itself, I think, kind of limits the time that there is for accounts to run up. It's a meeting at which really the immediate financial future of the body corporate is established. It's the same meeting where the owners would agree on the levies, they would consider the expenses, etc. of the body corporate, and at that stage already have to make provision for billing the developer for any utilities that have been utilized from the opening of the register until such time as council has effectively opened the individual rates accounts and utility accounts for the various sections.
It's quite scary. I mean, you've got to already at that stage be hands-on.
Correct.
With this property. I mean, it's your dream home. It's your white picket fence and your 1.5 kids and brown shepherd dog or whatever it is. And this is your dream now. You're getting into this property. You don't want to be sitting thinking about AGMs and budgets and finances and whether or not you're up to date and who to nominate. So how important really is it to be hands-on at that level of the development? You haven't even moved in yet. You might just be finalizing your tiles and doors and windows and so forth. Yeah. I mean, from the offset, you've got to be hands-on.
Yeah, absolutely correct. It's a vital component to owning a sectional title unit is being actively involved. Very few people realize that by virtue of their ownership of a sectional title unit, they are automatically members of the body corporate. And from that flows statutory obligations that they have towards their co-owners in the same scheme,
right.
And to their fellow members of the body corporate. And they all are jointly tasked with the responsibility of managing that scheme to its best advantage.
Okay, so the act, as you mentioned already a few times, that governs this scheme and all the owners who essentially are registered owners within the scheme is the Sectional Titles Act.
Correct.
But what else is there that will now keep all these owners in line and check and say, well, you cannot play loud music at 11 o'clock, and you cannot build your wall higher than this, or you cannot do this. Rules. I think they're called conduct rules.
Conduct rules, correct.
Is that the first set of rules that come out, or is something else prior to that?
So, yeah, just in practice, simultaneously with opening the sectional title register in the deeds office, we are obliged to submit to the deeds office for filing in their records a copy of the management rules and the conduct rules. Right. So the management rules essentially prescribe how that scheme is to be managed. There is a prescribed template, as it were, contained in the Act, which
is generally utilized
by most developers. They do have the right to amend those rules prior to registration.
And do they mirror the Act to a large extent, or are they specific to a scheme or type of scheme, should I say?
I think the management of schemes is a pretty universal concept, right. And very few developers will would ever stray from that path. It does make the management of the scheme a lot more practical, because there aren't any nuances that managing agents, trustees, etc. have to be aware of. So the management rules really dictate how the scheme is to be managed on a day-to-day basis. Okay. We have a second set of rules known as the conduct rules. Those are adapted to suit the type of scheme that has been developed. Right. That could deal with issues such as parking, the keeping of animals, noise levels.
And there in itself lies some very burning questions I'm pretty sure that viewers will have. We're going to take a quick break, Louis. When we come back, we're going to talk about these conduct rules. We're going to talk a little bit more about getting involved in these conduct rules and how you can change them if you want to change them. As you know, the phone lines are open. The number to dial appears on your screen every now and then. It's 011-086-770012 or 3. Call us while we go into the break, and we'll take your calls as soon as we come back from the break. Assalamu alaikum. Stay with us. Jazakallah. Assalamu alaikum, welcome back to Legal Ease. As you've already heard, we are busy converting this legal jargon about sectional titles into a legally but easy understandable language that hopefully you can make use of if you in fact need to. We're talking to Louis Kruger. He's part of the professional team, the property law team at Schindlers Attorneys, which is a full spectrum law firm in Johannesburg, and Louis is educating us on the sectional titles. Just before the break, we were talking about conduct rules. I reminded you also that the phone lines are open. The number to dial appears on your screen. So please dial in if you have any questions for us. Louis, you were talking about these conduct rules, and you were saying the conduct rules are essentially established to regulate the relationship, if I'm not mistaken, between the owners. Give me some examples of what are the more common conduct rules. You mentioned the thing about keeping dogs and keeping pets and things of that nature. Are those some of the more generalized type of rules?
Most definitely the keeping of animals is a very common and probably one of the most contentious rules contained. The bulk of our queries from the owners directly relate to compliance with those rules, the reasonableness of those rules, right. The imposition of fines as a result of owners not abiding by those rules. Quite often conduct rules are also utilized to allocate parking, exclusive use areas, right. If there are common entertainment areas, tennis courts, swimming pools, etc. The use of those areas will be defined and also regulated by the conduct rules.
Exclusive use, just touch on that, explain that for us.
All right. In a sectional title scheme, the owner would own a section in the scheme, which is obviously his property. Then there are areas of what we call the common property. That's all the areas outside of your individual section, right, which is jointly owned by all the owners in the scheme, right, and it is managed by the body corporate.
Like what specifically?
The road area, okay. The gardens, if they aren't specifically attached to the unit, access ways, swimming pool areas, entertainment areas. Most commonly would be parking areas, roads, any parks or...
Take balconies, for example.
Balconies may be, depending on whether they form part of the section or not.
And how would you know? You'd have to take a look at the sectional diagram?
You would most definitely have to look at the sectional title plans. It is quite common that balconies specifically, especially if they're not on ground level, are indicated on the sectional title plans.
As part of the owners?
As part of the actual section.
Right.
Which owners should also consider. Then they will also be rated. Their rates will be calculated on that combined square meterage.
Absolutely. And more importantly, and this is what I was really leading to, is damage to that balcony. Now, who should pay for that?
Yeah.
Paint. It needs a lick of paint. It needs to be bolted to the wall better. It needs to be, whatever, stabilized or whatever needs to be done. Who's got to deal with that?
If it forms part of the section, that responsibility vests with the owner of that section. If it forms part of the common property, such as most commonly the exterior walls of a complex, the perimeter walls, the guardhouse, the main gates, etc., the upkeep and repairs and maintenance of that, the responsibility vests in the body corporate.
Okay. What about a roof? The roof of the unit?
The roof of the unit is most definitely deemed to be common property, and in most instances including geysers, etc.
Right.
And is usually covered by an insurance that the body corporate maintains.
Yes.
And again, one of the very important aspects to be considered and discussed at that inaugural meeting.
Yeah. So all these things, who pays for them?
The costs are covered by the levies,
right?
And it's all these responsibilities that the body corporate has that affects ultimately the calculation of the levies.
Okay. Okay. So now we're getting into that realm now of what it is that is being formulated. So if you really look at it, it's a village. It has a group of politicians, or let's not call them politicians, probably a negative spin on it. It's got a group of leaders, so to speak, and we'll touch on those guys just now, that are essentially entrusted to govern this little town or little village, which is called, a sectional title scheme. And essentially, everybody's got to abide by it simply so that the village itself can continue for years on end. It's an interesting concept. There are benefits, but there's also disadvantages to owning a property in a scheme. Some owners argue that you never really own the property. You don't have complete free will to do with it as you please. What are the rules in respect of that? Building, renovating. Do I need to get council's approval, or do I just get the trustees' approval? And who made the trustees almighty? These are some of the questions that we often get asked in this field.
Again, I think it's important to consider the importance of those initial meetings. And at every AGM, all the members of the body corporate, being the unit or section owners in the scheme, will nominate certain of the owners to act as trustees.
Okay.
And in practical terms, the reality is if you own a section in a sectional title development which has 100 units, you are going to have a very hard time getting all 100 owners together frequently
for purposes
of meetings and making decisions on behalf of all the owners. So the concept there is that certain owners are nominated to fulfill the role of a trustee.
Right.
They are vested with certain rights and responsibilities, particularly in maintaining the day-to-day running of that scheme.
Right. So we nominate. So now the owners at this inaugural meeting essentially will nominate the first board of trustees. They'll also, if I'm understanding, they'll also say how many trustees there should be. So, for example, if there's 50 owners, we need 10. If there's 100, we need 20. Not exact numbers, but in that fashion. Now these trustees are essentially nominated, but when doing this, do we nominate Aunt Gracie, who's 96, just because she's not going to say much at the meetings? And do we nominate Joe Bloggs over there because he's a brawler and we think he's going to protect us if push comes to shove? How do you choose the trustees? And when you're making a nomination, what's the best, what criteria should be looking at in making this nomination?
I think that's a extremely valid point. I think we always need to consider that we are entrusting the future of that sectional title scheme into the hands of this trustees. So it's really important that we identify owners, professional people that would have knowledge, specifically those with financial history, management, etc., that are able to contribute meaningfully to and able to make decisions on behalf of the greater body of owners in the scheme.
You mentioned professional people. So take, for example, an attorney is an owner in one of these schemes. Is he entitled to charge for his services to the body corporate?
There are provisions in the Act that trustees may be remunerated. It is a decision which needs to be passed by a special resolution of the, most definitely. And the general consensus really is that you're contributing to your own home environment and surrounds. So it is frowned upon to insist on compensation, but most definitely not unheard of.
Yes, okay. And I suppose if there's a lot to do, if there's a certain hurdle that the body corporate essentially should get over, it needs to get over, and they require the services of this individual, and he would otherwise not be a member of the board of trustees, then perhaps maybe a little remuneration wouldn't be completely unreasonable.
Yes, most definitely. If his services are enlisted privately in his professional capacity and not by virtue of his position as trustee, I do believe that is a valid request. Quite often, though, with schemes where there are quite a greater range of administrative duties and is a more intense development setup, the trustees will generally appoint, also again by virtue of a special resolution, a managing agent. And I think that is what has created the scope for managing agents, is because of the specific knowledge required and the actual hands-on dedicated approach to effectively managing the sectional title scheme. I do believe that is what created the position for managing agents.
Right. It's a very interesting concept, because you kind of remove the onus of any specific owner, qualified or un, and you put it onto an independent third party who's not getting paid to do a job, and you best well do the best job you can. Because managing agents can sometimes be quite slack and quite neglectful when it comes to certain body corporates. I've seen that as well in my time. Louis, so the body corporate itself, there's a bit of a misconception in this regard. Some people ask, do I have to be part of the body corporate? You'd find that as a strange question. Why?
As we discussed earlier, most owners don't realize that by virtue of them owning a section in that sectional title development, that they are automatically a member of the body corporate. And it's at the body corporate meetings that decisions are made regarding the management, the finances, the future, the security, all the various aspects relating to property ownership are made in that forum of a body corporate. And quite often people neglect, as you said, they will identify other owners to kind of fulfill that role for them without fully appreciating that they are, by virtue thereof, affecting their own rights into the property.
And look, I mean, it's a taxing thing. We as attorneys in my firm, we sit on the board of many, as I mentioned to you, many trustees, a board of trustees, both as commercial and as residential trustees where we own properties. It's taxing. You have meetings after hours for trustees meetings. You can have 2 a month sometimes if something specific that you need to deal with. You're going to have annual general meetings, and then you're going to have an extraordinary general meeting. And that is something where you give notice out of the blue because it's something specific. So there's a security crisis, or there's leaking water, or there's a tree that's fallen down. It's in the middle of the road. We need to now deal with how we're going to remove it. It's a taxing thing. So if you're going to accept nomination as a trustee, because that's also important, am I right?
Yes,
accepting the nomination.
Correct. The procedure is that you would nominate an individual.
Right.
You would present the nomination to them at least 48 hours before the general meeting at which the nominations will be discussed.
Right.
And the person nominated has to accept their nomination in order for it to be tabled at the meeting.
Okay. So that's first has to happen then.
Correct.
Look, if you are wanting to, if you're interested in becoming a member of a trustees, sorry, I almost said body corporate, a board of trustees, you've just bought a new development, this is the show for you. So dial in if you have any questions. The number to dial, as you see on your screen, 011 086 7701 2 or 3. 086 7701 2 or 3. Phone us and Louis will be standing by to take your calls. Louis, we're talking now, we're talking about this nomination, and as I said, so before accepting a nomination, make sure that you've got the time to deal with this type of thing. It's a lot easier when you live at the property. A lot of times you have owners who own a property at one development or sectional scheme, but live at another, and then want to kind of be on the board of both, and becomes quite taxing.
Yeah, we do find in practice that those trustees or body corporate members who actually reside in the scheme have a more vested interest. They're also more aware of the day-to-day occurrences and runnings of the complex or development, as it were. And quite often they are more proactive.
Yes.
And there's a greater sense of urgency when it comes to dealing with matters that affect their day-to-day living environment.
Yes, yes, and it makes sense. It makes complete sense. Louis, what exactly are the powers that these trustees have? And in respect of these trustees, what are the rights that owners have? And I say rights because, yes, we understand that we've nominated these individuals, but does that mean we have to now sit back and we cannot get involved as owners of the scheme or in the scheme?
Yeah, that's a very, very good question. The trustees are tasked with the day-to-day management of the scheme. Their powers are limited.
Right.
If there are any decisions to be made which could potentially affect or prejudice any of the owners, there are various opportunities created, different types of meetings, different types of resolutions, which have to be adhered to. And the Act very, very clearly sets out what those requirements are, not just in the Act, but also in the prescribed management rules for the scheme. And depending again on what the situation is that the trustees are faced with and the types of decisions that need to be made, the Act and the rules will dictate to them what procedure needs to be followed.
Right.
I'll use as an example, if they want to amend the conduct rules which we spoke about recently, the trustees themselves do not have the authority to amend those rules. And I guess the simple logical explanation for that is you can't have a handful of individuals making decisions which affect the greater community.
Perpetually, because essentially those rules will essentially, for a time now, deal with the rules of the body corporate. We're going to take a quick short break. Stand by, everybody at home. If you've got any burning questions, please dial in. The number to dial appears on the screen, 011 086 7712 or 012 or 3. Call us. We'll be taking a quick ad break. When we come back, we'll be standing by to field your calls and to continue the discussion with Mr. Kruger. Thank you very much. Assalamu alaikum. Assalamu alaikum, welcome back to our show on sectional titles. As we told you just before the break that the phone lines are open if you need to ask us any questions regarding this, if you want to move into, if you're moving into a new development or just bought a house or are buying a property in an existing development or scheme, this is the show for you. Louis Kruger is standing by to take your calls. Please call us if you have any questions that you'd like to ask. We were talking just now about the amendment of the conduct rules and getting special resolutions and things of that nature. Let's leave that for a second. Let's just deal with something that's a little bit more technical, or should I say more complicated within a management, within body corporates and developments of this nature. And it's something that is really discussed at length at an AGM, which is the annual general meeting, as you indicated, must be done within 4 months after the financial year end of the body corporate. We're talking about the audited financial statements, or the financial statements, and then the auditing thereof. Take us through this, and what are some of the problems that can occur, and what are the owner's rights in respect of these financial statements? Because bearing in mind, if I'm not mistaken, it's their money that's going into a pot every month, and then from that pot, ultimately, the trustees are making decisions on what to use it for. So,
100% correct. The audited financials are circulated together with the notice of the annual general meeting. With the view that they'll then be discussed in depth at that annual general meeting. And really the annual financial statements set out the financial position of that body corporate. It shows how the levies that were paid by all the owners, trustees or otherwise have been allocated, how their funds have been spent, and also very useful to kind of see the financial strength of the body corporate. Quite often one could see patterns or difficulties which may arise in the following financial year emanating from the previous year. unnecessary expenditure,
Right.
increase in utilities rates, costs of the day-to-day maintenance.
Right.
And it also is the time where increases in levies are announced to the section owners.
Right. So when you talk about levies, so the payment of these levies amounts to a tax of sorts, right? If you don't pay these levies, what happens to the owner?
Yeah. The management rules will prescribe what the procedure is. Generally, the owners will be given a written notice of default or breach that they haven't, paid their required fees. And as with any debt collection process, the body corporate has the right to hand over that outstanding account to an attorney who does debt collection to try and collect those funds due to the body corporate.
Does the non-payment of a levy by the owner limit the rights of that owner in respect of the scheme?
Yeah. Most certainly, in certain instances, if there are arrear accounts and no adequate provision has been made, the person may be precluded from certain voting rights
good.
At these meetings.
So there is a punitive measure?
Correct.
There is a punitive measure. I mean, you can't sort of live there free will and still call the shots, I suppose.
Correct.
What about access to common areas? You're not paying for these common areas, can you be precluded from utilizing them? So say, for example, the public pool or the tennis court or the park that's on the property. Yeah. What about those types of things? Is that something you've seen before?
Not specifically seen, but I would understand that the access and the use of those areas would be well defined in the conduct rules. And I have seen that some schemes have tightened up on that and would attempt to limit someone's free use and enjoyment of those common areas.
Yeah.
However, I think it's important to bear in mind that together with the ownership of the section,
right,
the owner also holds an undivided share in the common property.
Right.
So in effect, you would be precluding
his common law property right?
His right to enjoy and utilize his own property.
I'm going to come back to you on that just now. We've got a call on the line, Louis. Let's take the call. We'll come back to you. Assalamu alaikum. Good evening, caller.
Hi, how are you?
Good, thank you.
We're the body copy is really less.
Sorry, ma'am. Your line is breaking up quite badly. Just say that again.
Hi, can you hear me?
Yes, I can. Carry on.
Recently looked into the sectional title scheme.
Sorry, ma'am. I apologize. Perhaps maybe try redialing the number again. It's breaking up quite badly. Apologize. We'll take your call again just now. Thank you. Sorry, Louis. There was obviously some interference there. We were talking about. So here's the funny thing, though. I understand that the Sectional Title Act obviously supersedes the conduct rules, right? Normally, if there's my understanding is that if there's a rule within the conduct rules that is in conflict with the rules of the sectional title, normally like with any other common law element, the statutory rule will essentially take precedence.
Correct.
But where there is a contract or a property law, so let's for example the Alienation of Land Act, where there is a rule in there that conflicts with the Sectional Title Act in respect of the limitation of rights in the event of non-payment, which act would take preference? I mean, it's a little bit of a tricky question, so I apologize in advance for it, but if it's something you can handle, please try.
Yeah, I think it's really important to always consider the act which creates that right and obligation and limitation.
Sorry, let's take this quickly before we get into the conversation. I apologize. Assalamu alaikum. Good evening, caller.
Hello.
Yes, good evening.
Yes, I buy the house, and sometimes the body corporate, they tell me, no, I cannot use the pool in the house. Hello?
Yes, may I carry on?
Yes, so they tell me I cannot put the spaza by the pool.
Put a what, sir?
Yeah, so I go to the pool in my complex.
Yes.
And they say I can't use the pool.
And why? Know? What reason did they give you for not being able to utilize the pool?
Yeah, because sometimes I put my spaza shop there, and they tell me no.
You've put your spaza shop there. Okay. All right.
Yeah.
Thank you, caller. You can listen off air. We'll address your question. Thank you. I mean, but awkward, I suppose, not necessarily a very common problem that one would face within the development scheme or within the sectional scheme. But your comments to that?
I think it really amounts to the reasonable use of the exclusive use areas, and most definitely any use of that area which infringes the right or privacy of a fellow owner. And if we heard the caller correctly, that he wants to conduct his spaza shop or dealings at the pool, while it might be absolutely convenient to those.
In fact, it might actually serve a common good within the
most definitely.
Scheme. But I suppose everything must be done within the interest of the scheme.
Correct. And I think that the conduct rules, as we discussed earlier, are most definitely being put in place to ensure harmony.
Yes, amongst all.
And allowing a owner to do that could really open the doors to a lot of.
Yeah. We've got another call on the line. Let's take this caller. Assalamu alaikum. Good evening, caller. Hello, caller. Are you there?
Can I speak?
Yes, please go ahead.
Okay, so ma'am, I just wanted to find out, I bought in a upmarket estate in Helderberg in the Western Cape.
Right.
Okay. Now, when I bought the property, they told me it's a secure estate and they got food patrol. The gates are manned with security. As the time goes by, they now told me that I must have my own house, must have been burglar barred, secure, and then I must look after my own security of my property. Also, in the area where I'm, it's a top estate. Okay, and I think there's only about 4 colors and there's about 400 Europeans in that estate. Okay?
Okay.
So the neighbor next door decided he wants to make a garden, and now the garden is like overgrown and affecting my view and all that.
Right.
Is there anything that I can do because I spoke to the estate, and they told me that it's between the owners, it's nothing to do with the state.
They're quite incorrect, caller. Thank you very much for the call. Very interesting question with a lot of very different elements to the question. Let's address the question of air. Jazakallah for the call, and you can listen off air. Let's look at this from a practical perspective. As you've heard the caller, there's a few elements to it. The element of a promise made in respect of security. I suppose the question there is whether or not there was whether the levy included security from the offer. What do the conduct rules say? Take us through it. Give us an indication.
Quite often, and we find very often that during the marketing of a new development, it is embellished, and various promises are made, and they're actually given effect to by the body corporate once established. And I could only assume that at that inaugural meeting, it's not something that was raised, nor has it been raised subsequently, but definitely something that needs to be taken up at the next AGM, placed on the agenda.
So if in fact they did say to him, listen, it's a very secure upmarket estate, you've got nothing to worry about, he walks in there, he gets burgled 3 or 4 times, now they say to him, listen, you don't want to get burgled, put up burglar bars. Is that an appropriate response from the trustees? And I would imagine it would be the trustees who are telling him this, because if not, the trustees then can make a decision to increase or perhaps maybe put into place a security levy.
Correct.
And say to all the owners, look, there's been a surge of crime in the area, we're getting burgled, let's increase the security, this is what it's going to cost us, are you prepared to jump on board?
Yeah, most definitely.
And in fact, can they even ask them, or do they have to ask them? If they want to get on board, surely the trustees make a decision and the special levy gets imposed.
Correct. In this particular instance is most definitely something that I would take up with the developer as a body corporate, if the developer is still contactable and around and involved in the scheme. Most definitely, specifically if people have purchased with a very real understanding of what was being offered. What we talk about when we talk about changes or improvements to the security aspects, those are known as non-luxury items.
Okay.
Those are almost essentials as it were.
Right.
And this can be decided by a special resolution. And just to give some clarity, a special resolution entails 75% of the owners present at a general meeting agreeing on putting in place certain measures,
Right.
or however they choose to deal with this aspect. But most definitely is something, and my direct advice to the caller would be to ensure that this matter is raised at the next general meeting, or alternatively to gather support from other owners. They would need at least 25% of the owners affected or interested by this to approach the trustees to insist on a special general meeting, so they don't have to wait for the next general meeting.
So
they
could
could
make a
have
decision on
could have a special general meeting with this specific
point to discuss.
as the item on the agenda, and then make a decision.
Let's take our last caller. We're almost out of time. I apologize to cut you off again. Assalamu alaikum. Good evening, caller. You can go ahead. Caller, you can speak now if you can hear us. Hello?
Hello, good evening.
Yes, good evening.
I'd like to ask you two questions that relate to conduct. If you are in a real levy, okay.
So, sorry.
If you are in real levy, are you permitted to put interest at exorbitant rate?
Okay, I think I got the gist of your question, and your line is breaking up quite badly, so I apologize. Can we just deal with that question very quickly? I think I understood the question, bits and pieces. If I'm incorrect, I hope this assists you somehow. Caller, I apologize. The line was breaking somewhat. Louis, I don't know if you heard clearly, but it related to the non-payment if you're in arrears of levies. So the caller said if you're in arrears with levies and you haven't been paying your levies, now you want to start paying your levies. Can you be subjected to exorbitant interest rates on the repayment of those levies? And that's an important question.
Practically, any penalties and fines imposed by the body corporate would be set out in the conduct rules.
Right.
And I do find it hard to believe that any forum of owners or body corporate at a meeting would consent to exorbitant rates being included into these conduct rules.
But with regards to interest, though, I suppose you'd have to look towards the National Credit Act, and you'd have to say, well, hold on a second, is the interest in line with the penalty interest that is the prescribed interest act that is charged? I think it's at 9.5% now for unpaid debts. Or is there a higher interest rate that they might have accepted to when they signed the body corporate rule? Sign the body corporate rules, rather. I suppose, but at the end of the day, my quick and short answer with that was, but no, certainly you cannot be subjected to exorbitant interest rate. It cannot be outside of the statutory requirements of the NCA or statutory requirements of the Interest Act or anything of that nature. It has to be within those limits, I would imagine.
Most definitely.
Yeah, and I think that if the trustees as a whole got together and decided that, well, now you're going to be charged 40% on late payments, for example, certainly that would be unlawful, and I would imagine they would have had a right of recourse.
Correct. They would have to refer the matter back to a general meeting.
Yes.
Because it would amount to the amendment of the conduct rules.
Yes, absolutely.
If they were imposing,
if it's outside of that, yes.
Yeah. If they were imposing their own rules, it would amount to the change of the conduct rules, which would be illegal unless it was done in the correct forum.
Well, and if that doesn't work, viewers and callers, then I would advise you to contact Mr. Louis Kruger. As I mentioned to you, he's part of the professional team at Schindlers Attorneys. His email address has been popping up on the TV screen, the bottom of your screen, every now and then. And you can also contact me or contact the show if you'd like to get Mr. Kruger's details if you haven't been able to get them down. And I promise you, as you've just very well seen, it's been an hour consultation that you've just had, and we fielded some questions, and still we haven't even touched on the elements of municipal accounts and what Schindlers Attorneys does in respect of municipal accounts. So please give them a call, give Mr. Kruger a call specifically. As you can hear, he's an expert in this field and on this topic, and God willing, he'll be able to assist you and hopefully settle all the woes that you might have. This has been another blockbuster edition, a show of Legal Ease, a beautiful start to the season, and we promise you many more riveting shows with a lot of interesting information and facts which you can practically use in your day-to-day life. Jazakallah for joining us. This is Legal Ease, the show that converts legal jargon to legal ease. Louis, thank you very much for attending as well.
Absolute pleasure. Thank you.
Assalamu alaikum rahmatullah.